Go.
Yes.
Your Honor, before we proceed to the defense opening, it's my understanding that counsel is going to be showing some videos to the jury.
Okay.
These aren't evidence yet. I don't know what's going to be shown, and I think it's unusual procedure. I've often considered using exhibits in my opening statement, and I think it's generally accepted that they're not evidence yet. So we can't be showing them to the jury unless they're in evidence, and we don't have any of this in evidence yet. So I would object to that.
Well, he does need to tell you what he intends to show. I got to turn things on here. He does need to tell you what he proposes to show, and me too. But the rule does not preclude their use during opening statement at all. What's up, Mr.
Your Honor, the first slide is a jury instruction, part of self-defense. The second slide is a picture of Joseph Rosenbaum wearing the maroon shirt for identification purposes. The third is a video at the Ultimate Gas of Mr. Rosenbaum having to be restrained. The fourth is a still photograph of Mr. Rosenbaum walking down the street after arming himself with the chain. The fifth is a picture of Joseph Rosenbaum taken from the video at the Ultimate Gas Station of him and Mr. Zeminski. The sixth photograph is once again a picture taken by Nathan DeBrune of Joshua Zeminski and Joseph Rosenbaum starting a fire at the trailer. And in that one, Mr. Rosenbaum is wearing a blue mask. Number 7 is a picture from the Ultimate Gas Station taken from a video of somebody who's commonly been referred to in this as Yellow Pants Man, Kelly and Joshua Zeminski, showing Joshua Zeminski armed with the weapon that was the first weapon fired at car source number 3. Number 8 is a picture for identification of Richie McGinnis. Number 8 is a picture of how Richie McGinnis was dressed that evening so he can be identified in the videos. Number 9 is Gaige Grosskreutz and his backpack taken from a video that has been agreed to be introduced into evidence. Number 10 is a still photograph of Gaige Grosskreutz running down Sheridan Road towards my client, arming himself. You can see him pulling the gun out of his back waistband. Number 11 is a still photograph of Anthony Huber holding his skateboard. And then number 12 is a picture of Anthony Huber holding his skateboard so you can see the whole skateboard, but dressed the same way as it is in number 11. Number 13 is Anthony Huber holding Mr. Rosenbaum back at the confrontation at Ultimate. Number 14 is the photograph of Jump Kick Man, the non-complaining witness, kicking my client in the head. 15 are 2 close-up photographs taken from that of the shoes of Jump Kick Man. 16 is a photograph of 11:40 p.m. when Kyle Rittenhouse is going out with Mr. Balch, and he's confronted by Yellow Pants Man and 3 other armed individuals that evening. And those photographs are blown up in 17, showing one individual with a noose, the other individual with rocks in each hand, and the other one a picture of the individual in the blue shirt armed. 18 is a video where Mr. Rittenhouse tried to return to the 59th Street car source and was stopped by law enforcement and the Bearcats. Number 19 is a still photograph taken from Mr. Rittenhouse at Ultimate as he's leaving with the fire extinguisher, his medical pack, and his gun heading towards car source 3. 20 is the video, what's called the infrared video, with Kelly Zeminski, Joshua Zeminski, Rosenbaum, my client, and Richie McGinnis circled and identified. 1148 is a still photograph of Mr. Zeminski's arm in the air firing the first weapon, the first shot. 22 is that same photograph from the video, same video, a photo just a couple of seconds later with 2 circles, one identifying Mr. Rosenbaum in yellow and another one showing Mr. Zeminski with his arm raised firing. 23 is a video taken from, and I always forget this gentleman's name, Lucas Zanin, from 63rd Street, right west of Sheridan, which forms the south edge of car source, and that's what Kyle was running to. There's approximately 100 people there bashing all the car windows, in there with pipes, bats, things like that, jumping on the cars. And you hear the first shot, which is Zeminski's, and people kind of stop a little bit. And then you see Kyle, you hear the next shot, and all of those people start taking off from car source. 24 is the video where Kyle begins leaving car source 3 after the shooting. And on that video, you hear somebody who's been identified as Kelly Zeminski yelling, "Get him, kill him," things like that. He just shot him. 25 is Gaige Grosskutz's video where he runs up to Kyle. It's about 7 seconds. Runs up to him as he's running down Sheridan. At that point, Mr. Grosskreutz is unarmed. He asked Kyle what he did. Kyle said, "I'm going to turn myself into the police. I had to." Photograph 26 is for BG on the screen. Photograph of an unidentified individual in a white sleeveless, or what's kind of referred to as a wife beater shirt, hitting Mr. Rittenhouse in the head, knocking his cap off. And then right after that, you see the next photograph from that video of circled Mr. Huber picking up after a skateboard, which he had used to strike my client in the head. The next photograph is a still photograph of an individual running up to Kyle as he's on the ground. There are several individuals in that photograph. One of those individuals being Jump Kick Man approaching from Kyle's right. And the next photograph is him kicking Kyle in the head. 30 is the picture of the close-up of that and the shoes. 31 is a photograph of Mr. Huber striking Kyle Rittenhouse in the head with his skateboard, held by the trucks in his right hand.
Held what?
The trucks of the skateboard.
Does I look like I skateboard?
They're called trucks.
Okay, wheels. To me, they're wheels.
Fine. The wheels with his right hand while he's grabbing Kyle's gun, his bare hand, touching Kyle's gun with his left hand. The next photograph is depicting Jump Kick Man getting up from the ground, Mr. Huber with his hand once again on the gun going forward and still having his skateboard. 33 is a close-up of that photo. 34 is, you can see the strap on Mr. Rittenhouse's gun being pulled taut. Mr. Grosskreutz running into the frame from the right of the frame. Next is Gaige Grosskreutz standing in front of Kyle Rittenhouse with his hands up. Kyle does not shoot. Next, Gaige Grosskreutz lunges forward with his right hand pointing directly, and that is when the shot is fired. And then there's a picture of Kyle Rittenhouse on the ground, individuals approaching him, one with a pipe, one with his hands up. He backs them off, does not fire. 11:51 him video trying to turn himself into the Kenosha Police Department and turned away. And the final is a photograph from the Antioch Police Department surveillance cam at 1:20 a.m. of Mr. Rittenhouse and his mother turning himself into the Antioch Police Department.
You know, I guess we don't need any witnesses. We've got the whole trial there. I thought the opening statement was supposed to be a summary of the evidence, not the evidence itself. This is, I think we're up to 41 videos and photos that are going to be seemingly introduced through the testimony of Attorney Mark Richards. This is a highly unusual procedure, Judge. Both sides will have the opportunity to call witnesses to talk about these things. We will have an opportunity in closing arguments to characterize these things. But to give the jury what the defense considers, and I'm not conceding that these things are all the evidence or even that a lot of these things are relevant, but for the opening statement to essentially be the entire defense case and all the evidence, showing it to them is highly unusual. I took the approach in my opening statement, and I guess I was not pushing the envelope as far as I should have, but it's always been my approach that I will describe what I believe the evidence is going to be, but I'm not the witness. I'm not giving them the evidence. That's what the testimony's for. We've had a stipulation as to the authenticity of a lot of the things that counsel's talked about. That does not mean that they're admissible into evidence. It does not mean we're conceding relevance to those things, and I anticipate that there will be some arguments as to the relevance of a lot of these things. We've already had some arguments about some of these things. So, you know, you stressed to the jury that the opening statements would be brief. It took 5 minutes for him to list all of those things, let alone what it's going to take to actually show them and play them for the jury. So I think as a general policy, Your Honor, and I understand it's not necessarily the law, but witnesses should be presenting evidence, not the attorneys in their opening statement. So I object to this procedure. I think it's overly long. It's duplicative of what the evidence is going to be. There'll be an opportunity through witnesses to present all of that. I think counsel should be describing what he thinks the evidence is going to show. That's appropriate. But showing them all the evidence this way, why do we even need witnesses at this point? I'll get up and I'll play all the videos I want to play. They'll play all the videos they want to play, and then we'll just be done without any testimony. That's not the way this trial should work. So I don't think this is a proper procedure, Your Honor, and I do object to it.
Okay. Well, first of all, are you going to be able to authenticate each and every one of these?
All of these come from exhibits that have been agreed or stipulated to the authenticity.
And they're all going to be relevant?
They all are relevant. They've all been...
It sounded like what I've already heard about, by and large. You know, the standard is not what you did or what you can do or could do. The standard is what the law allows, and I can remember studying this 50 years ago, that this was an acceptable way with judicial permission to make an opening statement. We see it more in civil cases than in criminal. It's not customary in criminal cases, but I've seen it done by your office. And I have to say that you're right. This is a record number in terms of the numbers. But on the other hand, there's a large number of crimes being charged and separate acts that are being asserted with respect to both the acts that the state alleges were unlawful and the defendant's claim of self-defense. So given that they do appear all to be relevant and they've been agreed as authentic, then I don't see any reason that I should interfere with his right to make an opening statement. Mr. Binger makes a good point in reinforcing my comment that this is supposed to be brief and informative. So keep it.
I don't think I'll be any longer than him, Your Honor.
Bless you. All right. Anything else?
Yes, Your Honor. One of the motions in limine I filed, which was not objected to by the defense, is that there be no reference to any pending or prior criminal cases or convictions with regard to Joseph Rosenbaum. The parties are aware, the jury is not, that there was at the time of his death a pending criminal case between Joseph Rosenbaum and his girlfriend, Carrie Ann Swart. and there was a bond condition that prohibited Mr. Rosenbaum from having contact with her. The purpose of my motion in limine, which, as I said earlier, was not objected to by the defense, was we're not going to talk about that. Now, I made a reference in my opening statement to the fact that Mr. Rosenbaum saw Ms. Swart that night and was basically was not allowed to stay with her, was not able to stay with her that night, so he left her residence. And I purposely worded it that way, Your Honor, because there are many reasons why someone may not be able to stay at someone's residence. It could be because of a bond condition. It could be for a myriad of other reasons. It's my understanding from an off-the-record discussion with counsel that he intends to go into this. He believes I've opened the door to it. I wanted a pretrial ruling from the court on this issue. We got one. And I'm now raising it because if it's going to be mentioned in the opening statement, I think this is the time to address this issue rather than in the middle of an opening statement. So I'm bringing it back up again. I do not believe that my statement opened the door to it. And frankly, my statement is not evidence. So I don't know that it can really open the door anyway. But by and large, I was very careful in the way I worded that. And I don't think it opened the door. I don't think, regardless, this is a relevant issue for this trial. Mr. Rosenbaum's conduct with regard to Ms. Swart has nothing to do with what was going on the street that night. So it is completely irrelevant, and I would ask that the court reaffirm its prior ruling on my motion in limine.
Your Honor, he can't have it both ways. He can't go and say he was at the house and he couldn't stay there and not. Why can't we tell the jury why? Because there was a no contact order. It's not appropriate. He thinks he didn't open the door, but he danced through the door. And he also talked about the hospital, got out of the hospital. He was in a mental hospital. And he's going to put her on the witness stand and we're not going to get to ask that? I mean, that's insane.
I was very careful about the word hospital, Your Honor. I believe it was actually St. Luke's in Racine, which is a medical facility. It is not a mental institution. This wasn't Mendota or Winnebago or something along those lines. And frankly, I'm not even 100% certain why he chose to check himself in. But again, whether or not Mr. Rosenbaum needed a new kidney or needed medications for mental illness or was going in to have his blood pressure checked has nothing to do with the events of this night. And frankly, it's just a backdoor way of attacking his character and suggesting to this jury that somehow because there's going to be an allegation from the defense that he had some sort of mental illness that had something to do with his behavior that night. I'd love to hear an expert on that, I guess, if they want to try and present that, and we can go down that line and we can talk about whether mental illness contributed to his behavior. What was his diagnosis? What medications were he on? We could open that door and go all the way through it, but that's a mini trial on an irrelevant issue, and if it's going to come in, there's a way to get it in through an other acts motion, which was never filed by the defense, and I certainly have not opened the door when I talk about the word hospital. This could be COVID treatment. It could be a kidney transfer. It could be anything. It does not open the door. And again, I was very careful in the way I worded that, Your Honor. You know, if I start talking about his medications or I start talking about, seeing a psychiatrist or something like that, that's different. Hospital is a very nebulous term that could mean a myriad of things.
Help me out here. I thought when I read the pretrial motions, and I know there were a series of them on which there was agreement, so I probably may not have the best recall of those because I didn't have to put too much thought into it. But I thought that the references or the statements which were attributed to Mr. Rosenbaum were, "I just got out of jail today." You're telling me that there was also discussion about hospital? No? Or
there's no video or statements or audio of Mr. Rosenbaum talking about the hospital. The only relevance it has, Your Honor.
Well, wait a minute. So
sure.
Is there testimonial? Are we going to hear testimony that he made statements that he had just gotten out of jail that day?
There's going to be statements to that effect.
Okay. In fact, your statement on your opening statement was. And I will tell you this. I'm going to ask you to try to reconstruct it for me, or if necessary, I'll have the reporter read it. But I don't recall the exact statement. I do know that I thought at the time, I'm surprised he's going into this, because it may trigger a response. So what exactly did you tell the jury?
What I said, Your Honor, is that that Mr. Rosenbaum had gotten out of the hospital that day
Right.
and was carrying around a plastic bag,
Right.
which is the kind of bag that hospitals give you to carry around your personal belongings. The only relevance that it has to this case
Well, I
is
don't know.
that's the bag.
I just wanted to get
Sure.
the statement.
Yeah, and I
Now,
was doing that because
okay.
the bag comes in, and
Okay.
that's the only
I understand.
relevance.
Okay, now, and you also made a statement about his being with the person by whom he was allegedly bound not to have contact.
That's true.
And do we know the exact scope of that order?
I believe it was a straight, typical,
Don't
no
tell me
contact.
typical. No.
We can look it up, Your Honor.
Yeah. Well,
It was
what
a
did you
bond
say about it?
condition.
What did you say about it?
What I said is that he had seen her after he got out of the hospital,
Right.
that he couldn't stay with her, and so then he left and essentially came downtown. And Ms. Swart will testify,
Why
and
did
she
you
will
say
talk.
that he couldn't stay with her?
I'm sorry?
Why did you say that he couldn't stay with her?
I said that because it explains why he left and came downtown. He's got a hospital bag, Your Honor. It's a little unusual, I think, for someone to be released from a hospital, have a bag of their personal belongings, go to their girlfriend's place, and then continue to walk around with it. That's a little unusual. We know what was really going on.
And by the way, how do we know that he had been there and had left? Is she going to testify?
Yes.
Okay.
Yeah, and so she's going to talk about seeing him, she's going to talk about that bag, and she's going to say she saw what was in that bag. And this comes into play, Your Honor, because this is the bag that was thrown at the defendant. There's been some allegations out there that this is a Molotov cocktail, or it's got chemicals in it, or it's got something that could cause the defendant harm. It had toothpaste,
Okay.
mouthwash, a water bottle in it. That's the narrow relevance of this bag.
Well,
That's why the
I'm
hospital.
not concerned. The relevance is not something I want to talk about now. I want to talk about what you said and
Sure.
why he thinks it is worthy of response.
He's misrepresenting the facts of the case to the jury by saying hospital when it was a mental hospital. Mr. Binger knows full well
Why isn't that a hospital?
he had gotten out for a suicide attempt.
So?
And
It's a hospital.
And let the jury know what type of hospital it was. Why he was acting the way he was. He was not acting appropriately. That's part of the defense. And,
Boy,
and then he goes and says, can't stay there. Why can't he stay there? Because there's a court order that says he can't. He wasn't supposed to go there in the first part.
And if he was on trial for violating his bond, then we'd have that trial. But he hasn't been tried or convicted of that because he's deceased. But, Your Honor, and by the way, we have the bond condition here. It's no contact, including the residence, electronic or third party, with Carrie Ann Swart and the Park Ridge Inn, which she stays there, and they had been staying there together until that criminal case started. So, you know, if we want to charge Mr. Rosenbaum with violating his bond, what good would it do? He's deceased. But yes, that is true. But again, it doesn't make him a criminal on this evening. It doesn't make his behavior
Okay.
help explain any of that stuff.
I don't think, as far as your opening statement, you need to respond to his statement about the hospital. I'll have to separately decide
Understood.
at a later point as to whether he had been hospitalized and for what. I don't know if that's admissible or not. I suspect that it is not, but I'll keep an open mind. As far as his not being there or not supposed to be there, again, I'm not sure that I want to hear about that in your opening statement. But again, I'll hear you later as to why you think that would be relevant.
Just because he's talking about my client traveling here from out of bounds,
Right.
and he's trying to say, oh, he had a good excuse for not being at home. He couldn't stay there that night. Well, the jury should know why he couldn't stay there.
Well, I don't know. If he can't stay there, he can't stay there. She could have kicked him out because she didn't like his having a hospital bag. I don't know. I'm not sure it's necessarily relevant. He was where he, like the defendant, was not supposed to be, allegedly, and we'll let it play out. But don't talk about those two things in your opening statement. Anything else?
No.
Okay.
Hello?
Would you come down, please?
Yes.
Okay.